Good morning. Good morning, and thank you for joining us here today. My name is Michael Dowry. I have the pleasure and honor of serving as receiver for the City of Chester. I'm joined here today by Mr. Vijay Kapoor, who serves as Chief of Staff on this engagement. Today's meeting was a special meeting called to discuss a recent court decision released by the State Supreme Court on Monday. We know there's a lot of interest in what does all of this mean, so we wanted to take some time here to walk through the decision and provide context as it relates to the latest amended recovery plan that was prepared in 2022. This has been a long time coming. This amended recovery plan was filed with the courts in November of 22, and here we are, January of 24, just recently receiving a decision. We think it's important for the public and employees to know exactly what this means and how we intend to move forward from here. So without further ado, if I could turn this over to Mr. Kapoor to walk through today's presentation. Mr. Kapoor.
Thank you, Mr. Receiver. Good morning to the members of public who are joining us this morning. As the receiver indicated, what we have provided or what we're going to present to you this morning is an analysis, kind of a high-level analysis of the State Supreme Court case that was issued this past Monday, and then to talk through a little bit about the practical implications that it's going to have on the City of Chester going forward. We have a PowerPoint here that we will post to the receiver's website. This meeting is being recorded. It will be uploaded to YouTube as well once we are complete. And you can also, as we'll talk about in a few minutes, find the majority opinion on the receiver's website. So let's go through the purpose again of today, and this is to talk a little bit about the court's decision, its impact, and then to also identify significant provisions in the now confirmed plan modification. For those of you who may be joining us, now or kind of in the middle of all this, this case really started with a plan modification that the receiver filed in November of 2022. And through that process, through the Commonwealth Court and now through the State Supreme Court, there were questions about whether or not certain provisions in that plan modification were permitted under Act 47 and under the city's home rule charter. Because, as many of you know, Chester is only the second city in Pennsylvania history to be under receivership. And this was the first opportunity that the State Supreme Court had to really look at the language in Act 47 and to rule on some of the questions that had come up over the years here. So what I'd like to do is, again, is to start with the court decision. You don't have to be a lawyer to follow what I'm going to talk about today, but I am going to spend a fair amount of time quoting the opinion. We are trying to keep this to providing facts and information. As we'll see soon, we are very thankful to the court for being so definitive and clear and unambiguous in its ruling, and for answering the questions that really we've been struggling with since receivership started back in June of 2022. So on slide 4, just again to kind of look through this process. Some of you, again, may be joining this more recently, but this process has been going on for a very long time. Starting back in November 8th of 2022, where the receiver filed the plan modification, and we went through a couple of different iterations of this. We had conversations with city elected officials at the time, matters where the Commonwealth Court had decided matters, and we went kind of back and forth. So this plan modification that was approved by the State Supreme Court and also by the Commonwealth Court has been through a lot of discussion, both with the receiver as well as the city. So back in November 8th is where we filed the original plan. On December 9th, we revised the plan and filed it with the court to include what's referred to as the Roots Compromise, when then council member and now Mayor Roots had suggestions regarding reporting structures, and that we took and included in the plan. At that time, the initial plan had called for the receiver to have sole authority over city operations and over the chief of staff / city manager. The Roots Compromise broadened that to include the mayor as well. So we had a 3-day evidentiary hearing on the plan modification back in January of 2023. Some of you may have watched that. Those were actually live streamed in the Commonwealth Court. On January 31st, the Commonwealth Court issued a ruling which confirmed most of the plan modification. And those provisions that it did not, it allowed the receiver to refile. And we did so, and the Commonwealth Court approved that plan modification on February 14th of 2023. And then on February 15th, certain city elected officials filed an appeal of the Commonwealth Court's approval of that. That matter then was pending before the state Supreme Court. In Pennsylvania, the state Supreme Court does not necessarily have to take any appeals that it gets. That's discretionary, just like in the U.S. Supreme Court, where certiorari can be granted or not. But in this case, the Pennsylvania Supreme Court actually used a very rare way of getting the jurisdiction to agree with the case. It was called King's Bench. A King's Bench basically allows the state Supreme Court to use its discretion to take up any appeal. And so the state Supreme Court did that. Oral arguments were held on this matter on May 24th of 2023. And then on January 29th of 2024, again, this past Monday, the Pennsylvania Supreme Court issued its decision affirming the Commonwealth's Court confirmation of the plan modification. Both sides here, both the receiver as well as the city, were represented by legal counsel. The receiver was represented by the law firm of Campbell Durant. Ms. Tiffany Allen argued the case. It was her first Supreme Court case. She did an excellent job from our perspective. She was joined on the matter by John McLaughlin and Ben Patchen, also of Campbell Durant, who assisted on the briefs. The city elected officials were represented by the law firm of Buchanan, Ingersoll, and Rooney. The case there was argued by Mr. Mark Pfeiffer, a partner in that firm. And two other groups joined the receiver in seeking to get the plan modification confirmed. That was both the Pennsylvania State Lodge of the Fraternal Order of Police and Delaware County. They both submitted amicus briefs in support of the receiver. Other unions, city unions, were contacted. They declined to do so, but both the Pennsylvania State Lodge of the FOP and Delaware County submitted briefs in support of the receiver. So let's talk a second about the plan modification and kind of what was at issue over here before we get into the decision. Where we were coming from, where the receiver's team was coming from, was we were looking to implement provisions in the plan modification that would work together to really ensure professional management of the city's operations, and therefore to ensure the provision of vital and necessary services. Under Act 47, the receiver has a duty to ensure the continued provision of vital and necessary services to the residents of Chester. What we sought to do in particular, as part of this, was to establish a clear operational chain of command. And a chain of command is basically, who do you report to? Who's your boss? Who's in charge? Is what we sought to make sure was very clear, because the way the city had been running was that it wasn't always clear who was in charge. It wasn't always clear who employees should listen to. And that's no way to run a city. It's no way to run any organization, much less a city that's serving 34,000 people. And so we sought, as part of that plan modification, to also suspend the administrative duties of city elected officials regarding managing day-to-day operations. As we'll talk about, the city of Chester elected officials may serve as department heads. But in practice, that is very rare across the Commonwealth. And in our view, and certainly in the court's view, that was not working for the city of Chester. And that threatened the receiver's ability to ensure that the city was providing vital and necessary services to its residents. So as we'll talk about as we get a little further, I know there's been there's been news articles written about this. There's a lot of questions about power and all this and that. The fact of the matter is, when we get to what exactly is happening here, is the city of Chester, based on the approval of this plan modification, is going to be run like just about every other city in Pennsylvania that is like it. And again, we'll talk about that as we get a little further here. But before, I know there's been a lot of interest over here, but in terms of kind of like what this actually means for day-to-day operations, it is certainly going to be a change from the way that the city of Chester has been run, but it's going to be run in a way that, again, is pretty typical of the way cities are run, certainly in Pennsylvania. So the majority opinion, you can find this at this website here on the essentially the state Supreme Court website. We've also posted it to the Chester Receivership website at chesterreceivership.com/documents. You'll see it probably in the lower left-hand corner of the page, of that web page. Our presentation today is going to quote extensively from the decision. Certainly we want to be as objective and transparent as possible. We will let the court's words speak for themselves in terms of answering the questions. We'll provide context to this, but the court, thankfully, as I said earlier, was absolutely clear and unambiguous. There is, in our view, no wiggle room here in terms of the decision that the court made. We're thankful for that because we've been struggling with these questions that the court has answered, as I said, from the beginning of receivership. What you'll hear me refer to as well as we talk through, and what the court did as well, is something referred to as the record. Whenever any court, any appellate court, basically mean a court that reviews decisions from a previous court, they have to use something called the record. The record is the establishment of facts in the matter. And an attorney cannot just stand up in court and make up things and say this is true and that is true. What has to happen is there is a trial court that establishes the facts. And in this case, that was the Commonwealth Court. And that was done through the 3 days of testimony back in January of 2023. Both sides in that matter were able at that evidentiary hearing to provide witnesses, to provide testimony, to cross-examine witnesses. And so everyone had a full opportunity to do so. And then the Commonwealth Court, based on that, made its decision and established a record and established facts. And in this case, the state Supreme Court used that record in coming up with its decision. And notably, the court used 10 of the 61 pages of its majority opinion to recount those facts in the record, which again were established in the Commonwealth Court. And you can read that on pages 11 through 21. And so again, I want to start here by quoting the decision by the state Supreme Court. Everything you'll see in this presentation where it says opinion is the majority opinion from this matter. And this is what the court said, the state Supreme Court said in its opinion. Although the Commonwealth Court struck several of the receiver's proposed initiatives, it concluded its analysis by reiterating the credible evidence of record demonstrates that aside from the severe financial distress plaguing the city also suffers from a municipal government that is internally dysfunctional. The city's current administrative organization and allocation of duties is the single greatest operational obstacle to the city's ability to provide vital and necessary services to its residents. Thus, the Commonwealth Court found not only is there no clear and convincing evidence that the plan modification is arbitrary, capricious, or wholly inadequate to alleviate the city's financial emergency, but the credible evidence establishes that receivers' proposed initiatives are necessary to save the city from the brink of financial doom. Again, this is not our words. These are the words of the state Supreme Court in its opinion, quoting the Commonwealth Court. And again, we're not going to go through all of the facts and all the details that led up to this. Those have been well documented, and you can read those on your own in the state Supreme Court opinion on pages 11 through 21. And again, they go through great detail those facts, and they cite directly to the record. So let's get to the decision here. in addition to kind of resolving the questions that we had here between the receiver, the Chester receiver, and the city of Chester, the opinion also, because it was really the first time that the state Supreme Court had been grappling with the receivership provisions of Act 47, it also clarified the broad reach of Act 47 and, by extension, the receiver's powers to address the city's dire situation. So this decision is going to have implications not only for the city of Chester, but any other city who may have to go through the receivership process. And the opinion noted that, again, quote, Act 47 is a remedial statute, and it must be construed liberally to effectuate its purpose of alleviating the challenges posed by financially distressed municipalities. That's on page 33 of the opinion. And what you will see here is that in the decision here, and we're going to go through the key points of the decision, the key questions in this next part of the presentation. The court was very clear about here's when in conflict, Act 47 is going to prevail with city issues. And again, I will provide you specifically the quotes from the opinion where that's described. So the first question that we had, a perennial issue that came up between the receiver and certain elected officials, was what controlled the city's home rule charter, which is kind of like its constitution, or Act 47 and any plan modification and any power of the receiver. Because again, a receiver is coming in and is exercising control over a local government. And the question is when there's tension between the home rule charter and the recovery plan, for example, if they say different things, who wins? Who comes out on top? And the court was very, very, very clear here to say Act 47 and the receiver prevails. The opinion at page 32, quote, wherever there is a tension between the city's home rule charter and Act 47, and by extension, between the home rule charter and the recovery plan mandated by Act 47, it is axiomatic that the home rule charter gives way. Now, axiomatic basically means automatic. It is self-evident that the home rule charter gives way. So it answers the question very directly. Any conflict between the home rule charter and Act 47 and any plan modification, Act 47 is going to prevail. And the court continues in this analysis, and again, I'll quote here, and it may be a little bit small, but again, we'll be providing the PowerPoint later. Act 47, again, from the court, Act 47 makes its precedence over any home rule charter abundantly clear in Section 704A, which states that confirmation of a receiver's recovery plan has the effect of imposing on the elected and appointed officials of the distressed municipality a mandatory duty to undertake the acts set forth in the recovery plan, and suspending the authority of the elected and appointed officials of the distressed municipality to exercise power on behalf of the distressed municipality, pursuant to law, charter, ordinance, rule, or regulation, to the extent that the power would interfere with the powers granted to the receiver or the goals of the recovery plan. So all of the italicized, I should say, words in here as well, those were italicized in the state Supreme Court opinion as well. So they are really trying to call attention here, and they are basically saying, as clear as day, when there's a conflict between Act 47 and the home rule charter, Act 47 prevails. And to the extent that city elected officials' power conflicts with that, with the authority granted to the receiver, or to the goals of the recovery plan, and we'll get to that in a moment, that's important language here, the goals of the recovery plan, the receiver's power takes precedence. The next thing that the decision looked at was court review of a receiver's plan. Anytime a receiver has to submit a recovery plan, he can't just make it up. He's got to submit the recovery plan to Commonwealth Court. And currently, the Commonwealth Court judge that is assigned to this matter is Judge Ellen Seisler. And so the receiver needs to provide the recovery plan or plan modification to the court. The court may have an evidentiary hearing, as it has done before, to determine whether or not the plan should be confirmed. And what the order clarified was that any court reviewing any recovery plan or modification must not substitute its judgment for the receiver. We'll talk about this in a moment. The Act 47 gives the receiver a great amount of deference, a great amount of discretion in coming up with the recovery plan. A court cannot substitute its judgment, but rather is limited to confirming the plan or modifications unless the court finds clear and convincing evidence that meets a specific and highly deferential standard of review that we'll talk about in a moment. Now, for most attorneys, if there's attorneys watching this, you know what this means. This is an exceptionally high burden. It is a very high burden. There is still a burden, right? The receiver can't just do anything he wants to do, but there is great deference that is provided to the receiver. And this comes from the state Supreme Court opinion. Act 47 does not direct the court, speaking of the Commonwealth Court here, to conduct an independent analysis of whether, in its view, the modifications are necessary. The determination of the necessity of the modification is committed to the receiver's judgment. The court may take evidence on the modifications at a hearing, but its role is limited to confirming the modifications, which it must do unless it finds by clear and convincing evidence that the modifications are arbitrary, capricious, or wholly inadequate to alleviate the fiscal emergency under Section 703E. Neither this court nor the Commonwealth Court are experts in municipal finance, and Act 47 does not ask us to be. The question for a reviewing court is not whether the receiver is in fact correct in determining that a particular modification is necessary to achieve financial stability. Rather, Act 47 directs the court to apply a specific and highly deferential standard of review to the receiver's determination. So again, this is kind of instructions to the Commonwealth Court and the reviewing court as to what its role is in Act 47. And again, very clear here that the role is limited and was done so purposely here. So another question that came up, that had always come up here, was particularly as it relates to the plan modification, the suspension of administrative duties for elected officials, is the question of, did the plan modification change the city's form of government? Because in Act 47, the receiver is prohibited from changing the form of government. And the court here was, again, very clear, very unequivocal. They said no. The opinion stated definitively that the plan modification did not change the city's form of government, as the statute, as Act 47, clearly says that recovery plans do not change the form of government. Again, let me quote from the opinion on pages 37 to 38. Although the Commonwealth Court concluded that Section 704B1 of Act 47 precludes initiatives that would change the city's form of government, this assumed limitation is inconsistent with the plain language of the statute. Section 704B1 states that confirmation of the recovery plan or any modification thereto shall not be construed to change the form of government of the distressed municipality. This is an unambiguous instruction to those who might construe a recovery plan, reviewing courts, for instance, that they should not view a recovery plan as affecting a change to a distressed municipality's form of government. The measures taken during an Act 47 receivership are temporary in nature, and the legislature specified that changes to governmental operations that may be needed in the interest of financial recovery do not permanently alter the municipal government and are not to be construed as a change to the municipality's form of government. So what the state Supreme Court was saying here was, in that first quote, the second bullet over here, is as they were reading the Commonwealth Court's decision, the Commonwealth Court seemed to think that a certain section of Act 47 would preclude initiatives, basically prevent initiatives that would change the form of government. And what the state Supreme Court is saying, respectfully, that's not what that provision in the statute says. What that provision in the statute says is a reviewing court should not treat any recovery plan or any provision in a recovery plan as a change in the form of government. So practically speaking, for all the non-lawyers out there, there is no argument going forward that any recovery plan or plan modification will change the city's form of government. That argument is now out the window, the court, again, is very definitive and very, very clear on it. So now let's talk a little bit about, as we go on, the suspension of authority of elected officials. So talking about here, okay, so what power does the receiver have over elected officials? What power does the plan modification have as it relates to the authority of elected officials? And the court, begins more analysis over here about really the broad extent to which the authority of city elected and appointed officials is suspended. And the opinion held, and we'll give you the quote in a moment, that consistent with the plain language of Act 47, city elected officials' authority is suspended not only where there is a specific and existing relevant recovery plan provision. So not only where you could actually point to a specific recovery plan provision that says this is suspended, but also where its exercise conflicts with the, quote, goals of the recovery plan. So this is broad. What this means is it's the powers of elected officials, not just with what's in the language, the existing language of the recovery plan, but also where their actions would interfere with the goals of the recovery plan. And let me quote, because this I think is a very important passage here on slide 17 from the opinion. Quote from the state Supreme Court opinion. Most significantly, as discussed throughout this opinion, Section 704A2 provides that a receiver's recovery plan has the effect of suspending the authority of the elected and appointed officials of the distressed municipality to exercise power on behalf of the distressed municipality to the extent that the official's authority would interfere with the powers granted to the receiver or the goals of the recovery plan. Again, continuing from the opinion. Although the city argues that Section 704A2 only comes into effect where the local officials' actions contradict some specific and already extant provision of the recovery plan, we find no such limitation in the statutory text. Rather, the official's authority may be suspended where its exercise conflicts with, inter alia, the goals of the recovery plan. So again, this is very clear direction to city elected officials, to the receiver, that it doesn't just have to be what's in a plan provision where power is suspended, but it also includes goals of the recovery plan. And so let me finish with this slide here that gets the decision, and then we'll talk specifically about the impact on the plan modification and what the implementation of the plan modification is going to mean now for the city of Chester's operations and going forward. So again, I'm going to be clear here that these are the words of the court. This comes from the opinion at pages 59 and 60. And this comes after all the analysis, all the review of the record, and this is the state Supreme Court, I think, really putting its stamp on this decision. And this is from the conclusion. Quote, the Commonwealth Court acted entirely within its authority in weighing the evidence before it and determining that conditions in the city justified the proposed initiatives. The General Assembly predicted that circumstances may arise in which local officials are unwilling or unable to accept a solvency plan developed for the benefit of the municipality. It decided that such situations may require the exercise of the Commonwealth's sovereign and plenary police power in emergency fiscal conditions to protect the health, safety, and welfare of municipality citizens. The city of Chester's local officials must accept the exercise of that power, whether they like it or not. And again, that is from the conclusion of the Pennsylvania Supreme Court's opinion. I want to move now. So that is, again, there's more information in the opinion. I think we've covered the main portions of it, but I want to talk a little bit now about the impact of that decision on the plan modification, because I think throughout this time, I think we may have lost kind of the focus as to what was really at issue here. There was a lot of focus on the suspension of duties. Again, we'll talk about that in a minute. But there's also other items here in the plan modification that are important, that are now confirmed in their entirety, and that, as the receiver will indicate, we will seek to implement now that, again, we've got confirmation from the state Supreme Court. So what I've got on the next couple of slides are relevant excerpts from certain of the plan modification provisions that the opinion has now confirmed that are in effect. And so, again, this is not I didn't include all of them from the plan modification, and some of the ones I included, I didn't include all the text in there as well. We're not waiving any, just so anyone asks. And I would suggest that folks refer to the plan modifications for all the provisions in their entirety. And so the purpose of what we're trying to do here is to highlight, and in particular, I think for city employees who for years have been asking who should they be reporting to and who is their boss, to highlight the practical impact of the plan modification confirmation on the day-to-day work and the chain of command for city operations. And I think this is also true for residents, to understand, okay, who's in charge of city operations. So let me start with a couple of the key ones here. And the first is with the chief of staff reporting, which is on page 30 of the plan modification. And for those of you who aren't familiar with Chester or may not know this, although we use the title, or although Chester uses the title of chief of staff in Chester, this position is effectively a city manager. Mr. Leonard Leitner, who is the chief of staff, who was hired by the city last year, really serves as a city manager. And so, again, under Chester's, the way Chester names it, they use the term chief of staff, but anyone who's really looking at this, think city manager when you see chief of staff. So direct quotes from the plan modification, which, again, the state Supreme Court confirmed. First, quote, "The chief of staff shall report to the receiver and the mayor." Second, quote, "City elected officials may contact the chief of staff for the purpose of inquiry, but they shall not direct the chief of staff relating to any matter in the line of his responsibilities." So two very key points over here. One, so the practical impact. Let's just talk about what this means day to day. One is the chief of staff's bosses are the mayor and the receiver. That's who the chief of staff reports to, the mayor and the receiver. And with respect to city, they can ask the chief of staff questions. They can make requests of him, such as constituent requests, right? They may get a call from a constituent and with a complaint or with an issue, they may take the request to the chief of staff, but they cannot direct him in his job duties. They can't say, you have to do this. We're commanding you to do this. They do not have the authority to do that. Again, the chain of command is very clear. The chief of staff reports to the receiver and the mayor. Again, I will note, this is part of what I would refer to as the Roots Compromise. In the initial recovery plan that was filed in November of 2022, we had the chief of staff reporting directly to the receiver. And I'll also note, too, for the mayor here, under the city charter, which, again, can be suspended here, the mayor is also referred to as the chief executive officer. And so, again, I think this, as we'll get to it in a moment, this kind of makes sense here. That the chief of staff would be reporting to the mayor, and in this case, also the receiver. Let's now talk about the administrative duties of elected officials. This is on pages 30 to 31. Again, this one's very important here, and let me quote from the plan modification, and then let me talk about what this means practically. So, quote, "The administrative duties of city elected officials with respect to day-to-day operations shall be suspended. The chief of staff shall have the ability to assign those administrative duties to qualified employees and contractors. City elected officials may not direct a city employee relating to any matter in the line of the employee's employment." All right, so let's talk about let's talk about what this means here. One is, it means that city council members do not serve as department heads. That power is suspended. it means that the chief of staff assigns department head duties. You know, I know that earlier this year, back in the organizational meeting, there was an issue, I think, between the mayor and certain city council members as to who has the right to appoint department heads. I think, frankly, that's going to be an issue that will likely have to be resolved. It's going to be the matter here doesn't resolve that issue in terms of the charter, but for the purposes of what we're working on, it's very clear that it resolves the matter insofar as no elected officials are serving as department heads. That is how it resolves it for the moment, and that city employees report through to the chief of staff, not city council. So city employees, I'll show an org chart in a moment. They report to their managers, who then report to the chief of staff, who then reports to the receiver and to the mayor. And city council members may not direct any city employee in their job duties. And again, they would not here participate in things like employee interviews, unless that's something that the chief of staff would suggest, or in things like labor negotiations or other types of matters like that. All those operational matters, that their day-to-day duties are suspended as it relates to those. Another part of the plan modification on page 31, compliance with directives and duty to provide information. Quote, city employees must follow the directives of the chief of staff relating to any matter in the line of their employment. City elected officials shall not interfere with the directives of the chief of staff or the receiver. All city elected officials, employees, or contractors shall be required to provide any information in furtherance of their responsibilities that the receiver or the chief of staff requests. So again, this is very clear here in terms of setting up who is in charge, very clear here in setting up the chain of command for operations within the city. And so, you know, what I want to show you here is I have a lot of words, but sometimes, you know, a picture is worth 1,000 words. We want to show you effectively what the organizational chart, the high-level organizational chart looks like here for the city. And what we have is the mayor and the receiver, and the chief of staff is reporting to both of them. As we said, the chief of staff has dual reports to the mayor and the receiver. And then all other city employees report to the chief of staff. That's how this is set up. Other city council members, there is no reporting between them, the chief of staff, and other city employees. Again, the city council members can interact with the chief of staff. They can ask them questions. They can make requests. All of that is, they completely have the right to do that. However, they have no ability to direct the chief of staff or to city employee or any other city employees. So if there's a city employee watching this and you've got an issue where a council member is asking you to do something, you need to go to the chief of staff. And you need to be very clear about that, because that would be an interference with the plan modification. That would be a very clear interference here. And we want to be very, very clear so that people are aware of this up front, so we don't have any issues as we go further down. And again, inquiry, you may ask questions of the chief of staff, but again, make requests, but you cannot here direct. And what I'll note is, you know, with the exception of the chief of staff or city manager also reporting to the receiver, this is how most cities in Pennsylvania actually operate. Chester has been the exception. So if you're looking at this and you're not really familiar with Chester and saying, like, what's the big deal over here? You know, this is not something that we kind of dreamed out of the blue. That is something that's odd in local government. This is actually how most cities do it. They have a mayor who's the chief executive. They have a chief of staff or a city manager who runs the operations, and all the other city employees report up through them. City council rarely, if any, times serves as a day-to-day department head. So again, we know this is a change for Chester. I don't want to minimize that, but in terms of what's being implemented over here, this is pretty much how everybody else does it and has been doing it for decades. Chester has been the exception. So let me get to another provision here that I think is also very important goes to the governance and goes to the operations of the city. Because there have been a lot of questions here about who hires employees, who fires employees, who has those authorities. And what is very clear here, even more abundantly so, is that that power resides solely in the receiver. So from the plan modification, page 41, quote, "The city may not hire, rehire, suspend, or terminate any personnel without the receiver's review and written approval. The city shall not create new positions or add to the city's complement without the receiver's review and written approval. The receiver shall have the sole ability to initiate or approve any hiring, enact layoffs and/or terminations, convert full-time positions to part-time, restructure department operations, including through consolidations or outsourcing, or reassign personnel subject to the provisions of collective bargaining agreements if applicable. This shall include employees appointed by city elected officials per the Home Rule Charter." So again, I'm going to be very clear here. The word "sole" here was in the plan modification, approved by the Commonwealth Court and confirmed by the state Supreme Court. And so the practical application of that, the practical impact of that is that the receiver, again, the receiver has sole authority to hire and fire city employees subject to provisions of collective bargaining agreements if applicable, so for unionized employees, including those appointed by city elected officials per the Home Rule Charter. That is all employees, effectively, is what that means here. Now, whether the receiver will decide to exercise that discretion, it's going to be up to the receiver to decide that on a case-by-case basis. But in terms of where that authority vests, that's in the receiver. So attempts to hire people, attempts to do so through council meetings or otherwise, the chief of staff does not have that ability. The mayor does not have that ability. It is solely within the receiver's powers. Now, I've got a couple of other provisions here that I think are important as well, just to, again, to highlight what's in the plan modification. And then I think the receiver had a couple concluding remarks. But another part of the plan modification, requests for proposals on page 47, quote, "The receiver shall have the sole authority," again, sole authority, "to determine the members of a selection committee for a city or authority request for proposals or any other procurement where a selection committee is convened. At least one member of city council selected by the receiver will be on any selection committee." So the practical impact of all that is, again, the receiver has the sole authority to determine members of an RFP selection committee or any other procurement where a selection committee is convened. That is through the receiver. I will also note here, in case there are any questions, the mayor is also a member of city council and would be included as a member of city council if the receiver so decided to include the mayor on these requests for proposals selection committees. So again, very clear here in terms of where that power resides. And then finally here, in terms of the plan modification, ethics policy. And again, this may be one that folks may have forgotten about, but we haven't, and we think this is something that is of importance to the city that I think could be an opportunity for the new mayor and for the new council to work on. And that is an ethics policy. And let me quote here. "The receiver, chief of staff, and city elected officials shall work in good faith to determine a citywide ethics policy for city elected officials and city employees. Such a policy shall cover areas including but not limited to conflicts of interest, personnel decisions, and disclosure. In the event that the receiver, chief of staff, and city elected officials cannot agree on such a policy, the receiver will submit the policy or policies to Commonwealth Court in the form of a plan modification. In such proceedings, the city elected officials shall be represented by the city solicitor. The chief of staff shall ensure the implementation and enforcement of such an ethics policy." So again, these are some of the plan modification provisions that were part of the plan modification, which are now in effect. They're absolutely in effect. Folks may be having questions as we go further, and obviously, we'll be working through all of this. You know, I hope that this has kind of provided some clarity here in terms of what the situation is, what the decision was by the state Supreme Court, and what's in the plan modification. So with that, I would like to turn it back to Receiver Dowry to make some concluding statements, and then we'll conclude this presentation briefing.
Thank you, Mr. Kapoor. It was a good bit of information you shared there over the last 45 minutes. Thank you for taking the time to create this PowerPoint and share this information generally with the public. In conclusion, I want to state that we are grateful to the courts for this decision. The last year and a half has been quite a bit of uncertainty, but the period actually goes back before that of really understanding the receivership powers and the best course of action. So we're grateful to the courts, the Supreme Court, for taking up this case and really establishing the record. As you said, I'm not a lawyer, so I won't pretend to use too many legal jargon, legal words, but this certainly gives us a better understanding of our powers and the working relationship moving forward. So we're grateful for that. Now, reading the decision, we realize why it took so long to put this together, to really digest the entire state statute, all of the court proceedings that have happened over the last 3+ years, and then to the arguments made here in this case. It's quite a bit to pull together, and I think again, grateful to the justices for taking the time and making the language clear, if you will, so we have a better understanding of the rules moving forward. Today's format was a briefing structure. We did not entertain a Q&A in this format, as there's a ton of information we wanted to get to and through, and wanted to have a clear presentation that completely walked through the entire decision. However, I will maintain an open door policy. My contact information is readily available, but please visit www.chesterreceivership.com. Send us an email, phone call, what have you. We certainly can take the time to have that Q&A, have the back and forth, and resolve any open questions that there may be. I think that concludes my remarks for today. And again, I want to thank everybody for listening in. This video will be available for review on YouTube, on our website, and through our Facebook page. So please seek us out and let us know if there's anything that you'd like to discuss in greater detail. As goes without saying, but I'll repeat it here, that we look forward to working with the mayor and council. We look forward to working with the chief of staff and continuing to push the city forward in the right direction. So nothing changes there. Our charge is still the same, and we will continue to engage. Thank you for your time, and thank you for joining us here today. Goodbye.